Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was arrested for beating his son at school. Criminal attorney Martinez, child abuse Martinez, cruelty to children Martinez. One day, I picked up my son from school. I'm separated from my wife due to domestic violence, and we have shared custody. My son acted up and I grabbed him by the ear. School security stopped me, and I called the police. And they called the police. Well, the concern I have is, let's talk about the domestic violence. How long ago was it? Were you still on probation for it? Or was this just a civil issue and it didn't go to criminal court? The reason is because if you were on probation, felony probation, or misdemeanor probation for domestic violence, and then you grab your child by the ear, that could very questionably be a violation of probation. And if your original domestic violence was a felony, you would be looking at a potential of 4 years state prison. If it was a misdemeanor, you'd be looking at a potential of 1 year in county jail. Now, I'm going to isolate just the part of grabbing the child by the ear. See, when it comes to Penal Code Section 273A(a), which is the code for child abuse or cruelty against children, it's a little bit murky. Generally speaking, corporal punishment is allowed here in the state of California with an open hand. Don't be hitting your kids with shoes or with the belt. Can't do that. But the punishment with regards to smacking a kid with an open hand also has to be reasonably related to the infraction that the child committed. You're not going to hit a child in the face because he dropped a pencil on the floor by accident. But if the child calls his mother a bitch, yeah, it probably would be a good idea to give him a little slap. I mean, you can do that. It's legal. It just depends on the circumstance. Now, you don't want to be leaving marks on a child because then there would be a legitimate basis for a violation of Penal Code Section 273A(a). Now, the thing is, but what makes this a little bit concerning is the domestic violence, because that domestic violence prior could be something that the DA could use to say that this person has a propensity for violence. And if the child was left with some marks in his ear, the DA would probably go with a misdemeanor 273AA, which still carries up to 1 year in county jail, and heaven forbid he was on probation. Now, even if he's not on probation, if that domestic violence case was a criminal case, it didn't just go to civil court, if that domestic violence case is a criminal case that is less than 10 years old, which more likely it is, that's still going to be priorable against you, which means they can still give you additional punishment if the DA does decide to charge you with child abuse. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court, call us, 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of robbery, but also petty theft.